To this story now, an East London court has nullified the ANC's Dr. W.B. Rubusana region, ruling in favour of disgruntled members. The participation of 37 branches and gatherings has been set aside. This ruling could affect the provincial elective conference, where Eastern Cape Premier and ANC Provincial Chair Oscar Mabuyane emerged victorious. I'm now joined by ANC Youth League Regional Chairperson Ondela Sokomani, who led the group that took the matter to court. Ondela, good morning and thank you very much for your time. You know, this case is a bit complex. You were leading the group of 5 yes who had brought that application to set aside the outcomes of the regional conference, and an order was then granted in your favour unopposed. That particular aspect of it being unopposed seems to have been problematic. What happened? Did the others not file their papers, or they filed them late? What exactly happened?
Good morning, and good morning to your viewers as well. Well, what had transpired is that the case, of course, it started in April when we obtained the interim order. But on the day in question, which was last week, the legal counsel of the respondents simply was absent without any reason. So it was not a matter of filing or not filing. It just did not come to court without reason. So court then took the decision to proceed in the absence.
All right. And then now to the rescission.
Yes.
Because straight after that particular matter, we then saw reports that they had now rescinded that particular order. And then you went on to state that when exactly would the matter have been heard? Where did they apply? Which is also the question we would be actually asking. What is the status of this matter now?
Well, we must state that the rescission took place under very peculiar and strange circumstances, considering that our legal counsel on a Friday afternoon was simply called to a Zoom meeting where the Eastern Cape Judge President was present together with the judge that had presided over the matter on the Tuesday. And without clear reasons and without a rescission application having been considered, it was said that the matter was rescinded. We must state that it is rather suspicious and would want to condemn and frown upon any possible nefarious relations that might exist between the Eastern Cape ANC leadership and judicial officers. Because we believe that in order for us to preside over a government that is stable, a government that and a judicial system that is credible, we cannot have judicial officers that are on speed dial, particularly on speed dial of politicians who are implicated in serious matters such as fraud, quite frankly, in this context of this particular case.
But I need greater clarity around... apologies for interjecting, but just for clarity, your legal counsel attended that particular Zoom session. What were the representations made by him? Because then that means both parties were present when they decided to rescind that particular order.
Well, what appears to us, well, the first thing is that they did not expect that it would have been that the judge president who would have been the first stop, if I can put it like that. Because remember, the judge president is the overall overseer of the operations of courts in the province. And so the expectation would have been that the deputy judge president responsible for the high court where the matter has been heard would have been the first person where any matters would have been raised. And so they did raise that procedurally this is rather strange, and that they've never heard that an order would be rescinded without a rescission application, but also the order is being rescinded without any clear clarity in as far as procedural or substantive matters are concerned. So it is rather strange, and it does appear to us that indeed there are undue influences that might exist over certain, or rather particularly the office of the judge president and political pressure that is being exacted on him by the leadership of the ANC in the Eastern Cape. And that for us then gives us skepticism. We are skeptical. We must state that on record that we are skeptical, considering that the judge president is the very same authority that must allocate a judge to hear the matter on the 28th, and therefore would not know whether or not the political pressure that was exerted on him to come and abruptly on a Friday afternoon interfere, or rather give directive, because they celebrated on Facebook. Quite frankly, the provincial secretary convened a cadres forum of branch secretaries and chairpersons to say, I quote, the judge president, the Eastern Cape judge president has rescinded the order. Was procedurally that would not even be the case. So it tells you that
we'll most certainly try and get the other party to establish the facts around what exactly happened in that Zoom session. But if we take it a bit back to the matter, the initial matter where they nullified the outcomes of that conference, the legal counsel of the respondents was not present. Why was the matter not postponed on that particular day when he was present, so that the judge could establish the whereabouts of the legal counsel?
Well, the understanding is that in court, if you are to be present or you are delayed because you are attending to other matters, you would indicate that indeed you will be coming. But without affording court the necessary respect to indicate that indeed you are coming when you understand, because when the matter was postponed on the 20th of September, the legal counsel of the respondents was present in court. They were fine with the date. So they were well aware that indeed there is a court date, which was last week. And so when they did not come to court, it was purely on their own accord, without any reasons given to court. And so court would have not then been held ransom to finalize this matter just because they took a decision to absent themselves deliberately without reason. Otherwise, it would then mean that in future, legal counsels of either parties in any other court, in any other matter, could simply just not come to court, and therefore that would mean that perpetually those matters would not be attended to and finalized, and therefore that would be denying the applicants justice that they deserve.
So your legal counsel did not perhaps tell you what reasons they furnished when they were part of that Zoom session?
Well, at the Zoom session, we are told on good account that there were no reasons given. The judge just alleged that she had made a mistake and there might have been some oversight issues, but there was no direct reasons given. And we do appreciate how the judicial officers of the High Court have handled this matter thus far, up until now.
But they stated, you mentioned something very important, that the judge conceded that a mistake happened in that respect, meaning then that what the other side is saying around the matter now being finalized unopposed was incorrect.
Well, that remains to be heard in court, because we don't believe that the matter was finalized unopposed, because it's them who were absent. Remember, it's them who did not come to court. So it was not upon us then to operate on the basis of their absenteeism, which had no reasons attached to it. And we will still believe that we have a strong case. That's why on the 28th, we are going to court. We believe that we have a very strong case, because there's no way that people convene an alleged bogus sketch of a regional conference in contempt of court, and that would be precedence that would be permitted by a court of law, that people who took delegates to conferences, delegates that were elected supposedly from branch general meetings attended by dead people, by people who are incarcerated, by people who are in a hospital, that would be set into precedence, into law, and alleged to be correct. We believe that we have a case. So we are not disturbed. By the way, the interim order still remains, which bars Rubusana from going to a conference, which they've already rendered that particular interim order as a mere academic exercise and undermined court. So we are not bothered, because we had the necessary foresight, the revolutionary foresight. And that's why we had approached court during the provincial conference of the Eastern Cape. That's why delegates from numerous regions had appealed to the national leadership of the NEC and the province at the time to say, remove Rubusana, because we run a risk of, in the future, when their matter of court is finalized, of having the credentials and the credibility of the outcomes of the provincial conference tainted, because they were barred from attending their own conference. So their participation here would entangle us in a far greater consequence than what you might foresee at the current moment, driven by, at the time, subjective interest and quite frankly, factional interests.
So this matter will be heard now on the 28th of October, am I correct?
The matter will be finalized on the 28th. We are confident about the matter. We are also confident that the renewal program of the ANC must not be anchored on injustice within the organization, because we have observed that those who shout the loudest slogans of renewal of the African National Congress are in fact the most unscrupulous characters. If you zoom closer to the operations, you will find that they are at the center of derailing the organization, of the decay of the organization, and the undermining of the processes of the organization. And we cannot sit as activists for social justice who are volunteers of the African National Congress and just lie down and roll over and not challenge that. For we would be betraying the very same revolution we are led to align with.